Welcome to the Ask Andrew show. It's the first live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the principal of the Greater Toronto Area family law firm, Feldstein Family Law Group. We have offices in Markham, Vaughan, Mississauga, and Oakville, and both myself and the entire firm practice exclusively in family law in the province of Ontario. Today, we're joined by special guest Cameron Fiske. Welcome to the show, Cameron.
Oh, thank you for having me, Andrew.
Now, my understanding is that you have a lot of experience in civil litigation. In fact, you do complex commercial litigation, insurance-related matters, class actions, defamation, civil fraud, and you regularly have appeared before this Ontario Superior Court and the Court of Appeal for Ontario. And you have argued a seminal constitutional case before the Supreme Court of Canada, and you're recognized by the Law Society of Ontario as a certified specialist in civil litigation. And in the field of defamation, you were successful in resisting an anti-slap motion that has been extensively reported both in case law and the media. And I'm sure that was a very interesting case. And I wanted to ask you, because I think most viewers, when they hear the term slap, think of somebody with a slap and they don't understand what it means. So perhaps you can explain that to our viewers.
Sure. So, I mean, the anti-slap legislation came in 2015, and its goal is to prevent lawsuits that are directed at stopping people from speaking about matters that are in the public interest. So I guess, for example, if I have an opinion that may not be a popular one, but just to use a generic example, it's perhaps about a politician, and it's in the domain of something that is of public interest, then that's protected under the legislation. So that's really what the goal of that legislation is, and it's certainly a noble goal, but sometimes it's overused to take out, or not necessarily to take out, but to attempt to take out legitimate defamation actions.
And I've heard of people in the family law realm who've gotten involved in defamation cases where their former spouse is not a politician, they're not someone in the public domain, they may just be a business person who owns a business, and one side makes some negative statements in the public domain about them, whether it's on a blog, website, some discussion forum board or something like that. And they try to argue that SLAP should be the reason to set aside the defamation, which that's where it comes into the family law realm. And when I've seen people suggest that, I scratch my head and say, I just don't get it. Do you see a way that could be able to enter something like the family law realm?
Honestly, I mean, not really. It's the problem is initially with that legislation, like I said, there's I think the expression I'd use is the road to hell is paved with good intentions. Like the overall purpose of legislation is very good, but it can be abused. And one area where we see that in is, and I'm referring to the family law context, is you'll see circumstances where, because that legislation more or less suggests that a losing party that is alleging a slap suit. So in other words, a lot of times the defendant might bring a motion to strike out, defamation claims saying that it's a slap suit. The actual statute is written in such a manner that they won't even have to have cost consequences for losing that motion. So what now it's a presumption against costs. Costs can be awarded. But I think what I'm getting at is that for a lot of people, there just is no real loss in bringing an anti-slap motion. So they'll try to delay a legitimate proceeding through such a motion, but it can be overcome.
So I think what I'm hearing you say is you're hoping that the judiciary exercises their discretion in cases where it's very clear that it's not a slap and awards costs, versus it being something, I guess, that would be more on the line of, I'll give an example, perhaps a former spouse of a politician defames the politician about something to do with their politics. I'll give COVID as an example. The person is a very strong advocate of the lockdown policies. And I'm not naming anybody here. It's a theoretical, but there's a politician, let's say, who's very strong in favor of lockdown policies. And then they go ahead and post something on the internet that says they're totally against that in their personal life. They don't live anything along those lines. And then the politician commences the defamation case and they respond with a slap. If somehow that's a close call, whether it is or isn't, I don't know. I could see the court having sympathy for that versus somebody who is just saying, my former spouse that is not a politician, is a businessman, is into all of these strange things in our bedroom, and I'm advertising it because I think that's in the public domain. Very big difference. And I would hope that the court, and I think I'm hearing you say the same thing, would say that's the kind of case where there should be costs awarded, because it's clear that you were bringing this motion for slap just to basically as an abusive process to slow down the process. Do you agree with what I'm?
Oh, I totally do. I mean, I like, and also we're right into a good controversial hypothetical on COVID. I love it. But no, I would just say, you know, with respect to that, what people will sometimes try to do is they'll try to cloak they'll try to cloak public interest speech with defamatory speech. So I'll give you a concrete example. This is why we won the motion that we did. An individual speaks to another party and says very bad things about the defendant that are all untrue, and then goes on to talk about political issues. So what you'll see in a lot of these circumstances is you'll see legitimate defamation, public speech coming together at the same time, and almost the hope that the second will save them from the initial comments. And that is not the case. That's what the court ruled in the decision that I was referring to that was widely reported, that I was involved in. You know, exactly, you're absolutely right. Costs are still possible when a party loses on an but I can't deny, like I can't, you know, I can't misrepresent. I mean, it's still very hard to get costs. And sometimes you'll see circumstances where your claim goes forward, but you still don't get costs for this kind of improper motion. So that's unfortunate, but it does happen.
Well, I guess I'm hoping that the law evolves because it's relatively new. And when it's a clear-cut case, it's the kind of case where there's cost versus one that you can see the argument, you can understand why they lost. And in that situation, there's no cost. And as you can imagine, as a family law lawyer, I get clients asking me every day that they want to say things are defamatory because, well, in family law, one thing that happens quite a bit is former spouses say a lot of negative things about their former spouse. And this really gets to tell me a little bit about defamation and the way that you would see it intersecting in family law.
Oh, it comes up a lot, and I'll be careful because we have so many of these cases. So I want to, I don't want to really per se try, reveal any of them in any sense, but it comes up a lot in terms of obviously the intersection with social media today. So we've got a lot of cases where one spouse will accuse the other of, let's say, anything from as severe as sexual assault or something of that nature on Facebook or on Twitter, where there's a significant following of other people that will see it that either know the spouses or quite frankly, just the general public. And obviously not just that sort of allegation, but others, other nasty allegations with respect to perhaps how they a parent and I mean, I want to be clear. Obviously, maybe there are circumstances where allegations are true. I don't want to come from the bent as if everything is always defamatory, but I'm just saying, what we are seeing in terms of, let's say, legitimate defamation cases in the family law context is a lot of abuse of social media. And I think that's one of the themes we'll probably talk about a bit today, but it's definitely a serious concern.
Well, there's a couple things I take from what you said. Number one, you focused on the word statements that are untrue. And I think what our viewers have to understand from a defamation point of view, you have to make an untruthful statement. So you can get into an argument about whether the statement is true or untrue. That's correct. From a family law perspective, there's a different concern. Number one, I'm going to say this. We tell all our clients when they hire us, we give them a do's and don'ts list. And one of the things we say don't do is, A, you shouldn't be posting in social media, and B, if you are, you don't say anything about your former spouse. You just don't. And even if you are making a truthful statement that is not defamatory, a family court judge may look upon it negatively. And I'll give the example. If you post in social media, and I keep on focusing on this because it's really easy to say, the former spouse is into all sorts of weird things in the bedroom. May not be anything illegal, but enough to really cause embarrassment in the community. I can see a family court judge saying, you're posting that to 1,000 people, and everybody in the community is going to hear about that. How do you think it's in the best interest of the children now for that parent to show up at a hockey game when all the other parents are sitting there whispering about all these strange things this person is into? So I try to tell my clients, it's not just the defamatory nature of it you got to be worried about. It's also the context of the family law litigation that it carries over into. Because if you're making statements that really, who cares? I mean, I've had cases where people plead all sorts of horrific legal sexual things about the other one. I remember in one case, the judge actually called myself and the other lawyer into chambers, and she said to the other lawyer, why did you do this? How does this help this family heal and co-parent going forward when you have all this horrible things about this guy that quite frankly were totally irrelevant? Who cares? You know, somebody like watching porn, and I'm not talking about anything illegal, but somebody like watching porn. Who cares? Who cares what the porn is as long as it's nothing illegal? And that was the kind of message. And you got to keep that in mind. So for people watching this and thinking, and I wanted to say that, who are thinking, well, I'm telling the truth, so it's okay for me to say it. It really isn't. And the other place I'd want to take from social media is don't do it, especially when your kids may be your Facebook friend or your kids' friends may be your Facebook friends. Not the kids like Facebook anymore, but some adults are on Instagram and TikToks and saying God knows what. And you need to appreciate there's cases where the court has said, you badmouth your former spouse on Facebook and your child is your Facebook friend. That goes to your ability to co-parent because now you're badmouthing the parent to the other child. So not a very good place to go. Now, we talked about the type of client that comes to you and they're complaining because the former spouse has made defamatory statements about them. Can you explain the difference between somebody who is sitting at home and making these kind of statements to family or friends versus a post in social media?
Well, I mean, that's a good distinction. Slander and libel is what we're talking about in terms of technical terms. So when the comments are being made to others and they're not, in print or they're not written down, essentially, they're slanderous statements. So certainly a dinner party, or let's use that as an example, where the former or the spouse or former spouse or whatnot is, let's say, defaming or making statements that are untrue about the other spouse to other people. That's slander. And if it's done in print, again, it's libel. Now, I wanted to mention this point because I do have a talking point that I want to be clear in terms of this area of the law, which is that there's a distinction between slander and libel in terms of notice periods and limitation periods. So the limitation period for slander is 2 years. So again, the verbal statements that are made to others. The limitation period for libel is 2 years as well, but it gets a little murky because when you have a broadcast, what's called a broadcast, your limitation periods are actually 6 weeks to serve a notice personally, and then 3 months to start a lawsuit. And the problem is, in the modern time, is what do we call a broadcast? Because, if we were to say go back to 1985, a broadcast would be the newspapers or, the CTV news or, whatnot. And today we live in a totally different era, obviously, of the internet, and we've got Facebook and WeChat and well, we once had MySpace, but that's pretty much gone. But, Instagram, Twitter, are these broadcasts? And the reason I flag this, and I do want to make this point, in our office, I don't think much of these social media forums should be broadcast, but it remains unclear in the case law. And so what we always try to do is to try to govern by the 6 weeks and the 3 months limitation period that I was referring to, in case the case law finds that Twitter is a broadcast, Facebook is a broadcast. If it goes that direction, we certainly don't want the client to lose out. But I'm just saying it's an open question in the law in terms of what a broadcast actually is. And we govern as if pretty much everything is a broadcast and liable, just to be safe for the perspective of the client. So I'm just saying to people that are out there, when you see a nasty post on Facebook, whether I personally believe that's a broadcast or how the Supreme Court will one day rule or not, doesn't matter. We kind of pretend as if it is in effect, because we don't want you to lose out on your claims. So bring that to the attention if you want to go forward as quickly. Bring that to the attention of your lawyer as quickly as possible, because you potentially might be facing 6 weeks and the 3 month limitation that I referred to.
Well, I think that's terrific advice for our viewers, to assume it's the shortest limitation period. I know we do the same thing with our clients. The other thing is, when does the limitation period start to run? Because if I'm that litigant and my former spouse made a post on social media 6 months ago that I just found out about today, does that mean I'm out of time?
No, I mean, at that point, well, it's an interesting question. I would say no, because quite frankly, you're discovering it at this particular point. But the problem is, I think we see like the obvious problem, and that's why I was saying act quickly earlier, because of course that's going to become a defense. You know, you're always safe if you're within the 6 weeks and the 3 months. You don't have to worry about whether your case, I'm kidding in a sense, but is going to the Supreme Court on if it's a broadcast. So you don't have to worry about that. And number two, you don't have to worry about any sort of limitation argument. Obviously, if you're seeing, no, you can't help it. If you don't see it for 6 months, you don't discover it. You haven't taken, reasonable measures. You haven't been able to see that in 6 months. Okay, it is what it is. You're going to face a defense of the limitation, but it is what it is. But I'm just saying that's why just act as quickly as possible. Suddenly you see a post and it's 4 weeks ago, get on it, because why even give them the argument where you're getting into fact finding about whether it could have or ought to have been discovered sooner?
Well, I think that's very practical and good advice that you're saying to our viewers, and always to your clients on that issue. But it's interesting because in the internet now, there's lots of times things don't come up for a prolonged period of time. The irony is, if you live in a small community and you have people that are Facebook friends with both of you, or Twitter, things like that, the practical reality is, I think most divorced people hear about things the other one is doing far quicker from busybodies in their life who will flip things to them. But, that community may not see it. You may not find out for a few months. So I would totally agree, which is, you find out about it, do something about it, especially when it's defamatory. Now, when somebody sees that something is defamatory, as an example, if I have a client who says, I want to sue my former spouse for defamation, I clearly tell them, I don't know, I really don't know defamation law. It's not my strength, so I refer them to somebody. But who hires you? Does the client hire you directly, or does the family law lawyer hire you on their behalf?
Well, generally, actually, just in my instance, I don't speak to everybody, but I usually will just be retained by that client, and there'll be some sort of provision in the retainer so that there can be open dialogue with family counsel. But that's my personal preference. So there's no specifically right answer to it. It certainly could be that the family lawyer retains the other lawyer. There would be nothing that would bar that, but that's just my preference. But, so I think that, as I said, I won't necessarily speak for everybody else. And I think people should just be aware, if they're out there, in terms of, whether they're retaining the lawyer directly or their lawyer is, that neither are necessarily wrong. But what I will say with respect to defamation is, it's a tricky little area. I'm a commercial litigator. So funny enough, commercial litigation almost has an element of general practice to it, different from, say, family or criminal, because there's so many different facets of it. But defamation is a subset, I would say, within the civil litigation commercial area. And I happen to do a lot of it. I'm very interested in it. But you should go to somebody who does have specific experience with defamation, because it's a very good way to go the wrong direction if you have an inexperienced lawyer. There are specific pleading requirements, as I talked about earlier, specific notice requirements, but also specific pleading requirements, pleading the specific words. And a lawyer that doesn't have any experience in defamation can very quickly, I guess the word botch comes to mind. I wish I could think of something less colloquial, but they could definitely take a case in the wrong direction by not following actual pleadings requirements. So it's good to whether it's you or your family counsel that goes out and retains that lawyer, it's good to find someone who really has litigated and has a proven record in that field of defamation.
Well, I certainly think that makes good sense. And that's why I prefer when my clients ask me for a referral versus they find somebody, because then sometimes you get into the battle of two lawyers. And even if I don't practice in defamation, sometimes you can sort of get a vibe when you're talking to another lawyer that they really don't understand what they're claiming to understand that's better than a non-lawyer. But I'm wondering, somebody comes to you, let's say I refer them or another lawyer refers them, or they find you on their own, and they say, my former spouse has been defaming me. And you say, okay, what did they do? And they say, they've said all these horrible things. I give Facebook as an example because it's the first one that comes to mind, but Facebook or Twitter, or they've done some TikToks making fun of them. What do you say? How do you start with that type of case? What do you do?
Well, I try to, I really give clients a full picture because, quite frankly, business is good. I don't need the business. I don't want people to start unnecessary litigation. And we have certain ethical obligations on top of what I do, those personal points that are there. I want people to know when they get into these kinds of disputes that it can be a long road, and it might be a road that you don't necessarily find that satisfying. So somebody comes, let's say, and they have found, let's say Facebook, we'll just pull that out of the air, comments that are nasty against them. Sometimes we try to look at avenues to I guess, end or cut things off at the pass early. So for example, I would generally say, okay, let's do the notice letter. So that we're in compliance with the, if it is a broadcast, that we're in compliance with the limitations within the 6 weeks or 6 weeks of awareness. And it's always possible that the matter will end there, that the client won't want to, it's possible that the post will be deleted, that the potential defendant will see the harm of going forward with the matter. By going forward, meaning that they don't stop, the defamation. There is the possibility, if it gets to it, to having to seek injunctive relief in order to stop the behavior. But I really attempt at the beginning mitigation efforts. We're trying to avoid any issues with the limitation period, but also hopefully it actually ends in not needing to do a lawsuit. Because, at the end of the day, a lot of people come out of a lawsuit feeling somewhat dissatisfied. Their ultimate damages might not be that great. And they end up paying a lawyer, for the pleasure of being involved in a long process. So I really try to mitigate efforts at the beginning, as I've said. And of course, if it gets to the point, and I'm assuming from your question, we're talking about that the family proceedings, let's just assume that the family proceedings are done and the final order is done. And we're obviously talking about a separate defamation action because it involves third parties that are not, we'll probably get to that, but not within the family. Look, this can be a long process. Let's preserve the limitation. Let's put out a libel notice that specifies exactly what the conduct is, tells the person to take it down, tells them to cease and desist. And it's always possible that it'll end there. It's good to at least come to a lawyer. This is what I'm trying to say, to start that initial process, because it's not necessarily that expensive. If it goes farther down the road, well, yeah, then maybe there has to be a statement of claim. Maybe it goes farther.
Well, and I'm sort of getting a sense, but let's now put your head on your head of a different side of it. The client has gone to another lawyer. Your client is the one who made the defamatory comments on social media. And they come to you saying, I got this letter from some other defamation lawyer. What do I do?
I mean, I've had that circumstance happen as well. I think statistically more likely represent a potential plaintiff or a plaintiff, but absolutely have also represented defendants. Or potential defendants, let's put it that way. And, well, listen, I guess number one, again, back to the notion of mitigation. If they've received the libel notice letter, it's not always certain that that's going to eventually end in a full-blown lawsuit and go on for months or years. So, if there are posts that are objected to, it's certainly not a bad idea to take them down. Posts, whether it's Facebook or other social, we're always sort of going with these social media, I guess, in our examples right now. But, absolutely, I mean, take them down. But, there certainly can be a response. We can respond to such a letter. It's tricky, turning on the extra hat, because you're almost saying to me, I guess, assume in effect guilt, although guilt is more of a criminal term, but assume that they've done it and that there is defamation.
Assuming that there may be defamation in there.
Yeah. Okay. Like, making that assumption. Yes, absolutely. Mitigation efforts are along the lines of what I've just said, to stop. And every once in a while, I mean, some degree of dialogue with the lawyer that's actually sent it can cut. I mean, I'm talking about between counsel, by the way, can cut something off at the pass, because a lot of times that's what you want to do. You don't want to get into months or years of litigation. So it's still good to go to a lawyer rather than to either just put it on the ground and do nothing, which is I just don't advise. But sometimes even that dialogue between counsels, assuming that the notice letter from the plaintiff was sent from counsel, is a way to cut something off of the pass and taking the posts down. I can't guarantee that, though, because no matter what, even if you go out and apologize, there's still case law that says you could be liable for defamation. So, and I'm not necessarily advising somebody going out to apologize. So I'm just saying that's not necessarily going to be the end of the road, but certainly mitigation along those lines is what I would advise. And if we have to get into an actual case, then sure, there are still defenses that are available.
And I'm assuming that the damages, at least for my limited reading, especially if there's been apology or removed, is going to be hard to get a significant award of damages unless there's something unique to your specific case.
That's correct. I mean, an apology is certainly a mitigating effort. That's what I was talking about earlier. It doesn't, again, there's case law out there. It doesn't necessarily forbid an action, but it's a mitigating effort, and it would go to overall quantification of damages. Basically, people would be surprised. We've seen maybe a lot of large damage awards in the United States, and the odd one here, the famous Hill versus Church of Scientology case from the Supreme Court of Canada in the 90s. But most defamation awards are not that substantial. That doesn't mean this isn't serious, but it's just that they're not that substantial. They could be, oftentimes I'm seeing cases in the range of 20,000 to 150,000 in a lot of matters, not the kind of, the Hill case that I said, which was $1 million or whatnot. So the awards are not necessarily that large. Again, that doesn't mean it's not serious. And it's not good to have a reported decision with your name on it on legal sources like Can Lee showing you're defaming people, because that can affect you with members of the public looking your name up on a source like that. So don't take it lightly. But I mean, just to finish on the apology, yes, that will go into one of the factors that a judge might assess in terms of damages. But again, if I'm playing ball on this side as if I'm the defense lawyer and my client has done it, so to speak, in a sense, I'm always I'm looking at mitigation efforts, but I won't always necessarily say we go out and apologize. That's why I was that may be a factor. That may be what we do. Each case is different, but that's why I was talking about some dialogue with the other counsel, between counsel. It's not a bad idea. Sometimes you can cut a case off at the pass without it even getting to a lawsuit through that.
So I think what you're saying, because we're almost out of time really, is that if you think your client did the defamation, you have some communication on a without prejudice basis for settlement purposes, and you're saying to the other side, basically, my client's going to take it down. My client will apologize if need be. And will that make this go away so there's no damages? And part of what the other lawyer is probably going to think, damages aren't significant in Ontario. And if your client goes and does that, what is this claim really about? Because the value of it may far exceed what my initial retainer is just to do the statement of claim.
Andrew, I think you've summarized exactly what I was trying to say, and perhaps in even more coherent fashion. So I'll take exactly as you say. Those are my words exactly.
Okay, so I want to make sure our viewers got it. Cameron, I wanted to thank you for being here today because you gave some really practical, common sense tips to our viewers that I think is terrific. So it was a pleasure having you.
Thank
I
you.
appreciate that you were here sharing your experience and expertise. The next Ask Andrew show will be in February. It's now, this was our first one going back to a 12 o'clock time, and we'll be publishing that date in February. And if you have any requests or ideas for future shows, please email them to us at info@feldsteinfamilylaw.com. And thank you for watching.